You finally buy that premium appliance you've been saving for. You plug it in, push the lever, and it pops, smokes, and dies. Before we dive in, note that I am providing general education here, not formal legal advice. When you take that broken item back to the store, you'll often hit a brick wall. Customer service representatives are frequently trained to rely on consumer frustration, banking on the likelihood that you will simply give up and leave. We are going to counter that strategy with a structured methodology designed to bypass store-level rejections and force the retailer to honor your legal remedies. Understanding these specific protections shifts the balance of power. It turns a standard return into an evidence-backed demand the store is legally required to address. Your baseline protection is the written warranty. This is the manufacturer's documented commitment to repair or replace the product if it fails within a specific timeframe. At the register, you are offered an optional protection plan. Your standard written warranty remains valid regardless. The third column represents the implied warranty of merchantability. This federal guarantee mandates a product must work for its intended purpose. A fridge must cool food. Because this is a federal standard, a store's individual return policy cannot supersede it. If a product is defective, the law requires a remedy regardless of what the sign behind the counter says. Even a limited warranty carries strict legal weight. It may restrict coverage to certain parts or labor costs, but the manufacturer is still obligated to address the specific failures outlined in their own terms. Identifying these three distinct types of protection provides the baseline knowledge you need to navigate the first level of retail defenses. Once you know your rights, you must gather the facts. The goal here is to create a documentation package that cannot be dismissed on technicalities. Step 1 is securing your proof of purchase. Check for an email confirmation, a retailer app purchase history, or a credit card statement. Step 2 is locating the warranty coverage terms. You can find these in the box or by downloading the official PDF from the manufacturer's support site to confirm you are still within the valid time limit. For Step 3, find the serial or model number on the unit itself. Recording this number ensures your claim is tied to the exact item you purchased. Step 4 is about visual proof. Use your phone to take high-resolution photos or video showing exactly how the product is failing to perform. Organizing your claim with this level of specificity leaves no room for the store to argue user error or a lack of documentation. You have provided all the factual requirements they need to resolve the issue. Step 5 is initiating contact strictly in writing. Send a formal letter or email that includes the purchase date, a clear description of the defect, and the specific remedy you are seeking. Verbal complaints at a service desk rarely leave a record. A written trail creates a legally binding timeline that the company's corporate office can later verify. If a representative refuses your claim, move to Step 6. Demand a written reason for denial on company letterhead. Making this request often ends the stalemate. Most employees are hesitant to put arbitrary or incorrect store policies in writing, as that document provides you with evidence for an escalation. If the store remains stubborn, follow Step 7 and escalate. Move from the store supervisor to the manufacturer, then to your state consumer protection office, and finally to the FTC or small claims court. As shown here, the Federal Trade Commission is the federal authority tasked with stopping deceptive business practices. Mentioning that you are filing an FTC report communicates that you understand the regulatory landscape. Presenting a documented, evidence-backed claim forces the corporation to realize that ignoring you is more expensive and legally risky than simply honoring the warranty. You will likely encounter rehearsed scripts designed to make you give up. You can stop this friction by preparing your counters ahead of time. When they say you didn't buy the protection plan, remind them that your rights are secured by the manufacturer's warranty and the federal implied warranty, neither of which require an extra fee. If told you have to contact the manufacturer yourself, clarify that if the failure happened within the store's return window, the retailer is responsible for handling the defective unit. To the claim that physical damage voids everything, point directly to your photos. Show that the failure is internal or a result of normal wear, placing the burden on them to prove otherwise. Breaking these scripts proves that you are an informed liability. Once the store realizes you cannot be easily misled, they usually pivot toward a resolution. Review your finished package, the proof of purchase, the defect photos, the serial number, and your written demand for a remedy. Presenting this level of documentation completely changes the dynamic of the conversation. You are no longer asking for a favor, you are documenting a requirement. You can find further guidance on the official FTC website. If this plan helps you resolve a dispute, subscribe for more tutorials on navigating consumer rights. Holding companies to their legal promises ensures that the products we buy actually meet the standards we were promised. This methodology gives you the tools to act as your own advocate in every marketplace interaction.